So hello again, this is Devon Carter from Cartech Consulting. We are here going to talk about the second part of the security awareness training, talking about regulatory compliance. We'll basically be reviewing some of the regulations that you should be aware of as a business owner, as a law firm. This is important because it gives you an idea of uh, what risks you could be incurring based on what you do. Also, it'll help you when trying to choose a consultant or someone to help you to secure your environment. So let's jump to it. So regulatory requirements, basically we're going to talk about these four things or four regulations: the payment card industry or PCI requirements, GDPR or General Data Privacy Regulation, the California Consumer Privacy Act, and the Health Information Portability and Accountability Act, or HIPAA. Okay. First up is PCI. So PCI, or payment card industry, it's important to understand that this was done by the major credit card firms, and basically they wanted to put together some requirements for people who would be able to accept credit cards. Right, they wanted to ensure that the people accepting credit cards were having a minimum security baseline so that they had a better indication of whether there would be any fraud or any theft, and make sure they were protected. Why? Because the credit card vendors didn't want to incur any penalties or any issues themselves. So by them working together and forming this industry standard, they now push this down to everybody who processes credit cards, and everybody who processes credit cards are responsible for being PCI compliant. So that first bullet says you're responsible for ensuring your compliance as well as your vendors. It means that. So if you are processing credit cards, you have to make sure you're in compliance. And if you are working with a vendor who's processing credit cards, you have to make sure they're compliant. The level of security is required, depends on the amount of transactions you run annually. So the number of credit card transactions that you actually handle each month will determine which level of merchant you are, which will determine potential fines and also requirements for becoming PCI compliant. Additional multi-level authentication requirements, and just to make sure you understand that security in all phases is an ongoing process. New vulnerabilities are discovered on a daily basis, and so you have to keep going through the security process over and over again continuously to ensure that you're catching and staying up to date on all the vulnerabilities and protecting yourself and therefore protecting your clients. So PCI requirements, there are 12 of them at a high level, and we're not going to go deep into these, but I just want to make sure you're aware. Installing and maintaining a firewall and configuration of network systems, avoiding vendor supply user defaults. I mean, that's a big one. Most people are always using, password. They never change the passwords on their home routers and things like that. For your business, it's the same thing. Protecting cardholder data during storage. Once you process the credit cards, if you're storing that data on your servers or your computer somewhere, you need to ensure that it's protected. Make sure it's encrypted. Using encryptions during cardholder data transmissions and open and public networks. So if you accept credit card payments over the web, ensuring that your website is HTTPS compliant or SSL compliant, so that you are protecting and encrypting your client's data as it travels over the internet. Using and updating antivirus software. Seems simple, but it's very important, and unfortunately, many people don't do it. Develop and maintaining secure network systems and applications. So if you're building your own apps, or if you're having somebody to build a new client-facing app for your legal clients, then you want to ensure that they're doing it in a secure manner. Restricting user access to cardholder data. Everybody in the law firm should not have access to cardholder data. Right. And then if you have multiple lawyers in your firm, each lawyer should probably only have access to their own client's information. So being able to restrict that and track that is very important, because it'll help give you a better indication of who's doing what with regards to cardholder data. Creating unique IDs for users who need access to cardholder data that matches up with number 7, so you know who's accessing what. restricting any physical access to cardholder information, lock the doors, right? Have a badge scanner to get into the room, have cameras, have all these basic security things so that you know who's doing what on your system. Tracking and monitoring all access to network systems and data. Something like Office 365 with Active Directory, that gives you the ability to see who's logging into the network when and what they're accessing. That will be a great help to you as you're tracking issues. Testing security processes and systems, and maintaining information security policies. That last one is very important because most people don't have information security policies. The importance of a policy is that it basically gives you the roadmap, or it gives you the high level statements about what you're doing for security. And so without kind of a vision for what you're doing with your security in your corporation or your law firm, then it becomes difficult to really instrument this stuff because you're not designing to anything. You're just throwing things in place. Now, these are the different merchant levels for PCI, right? And as you can see, merchant level 1, over 6 million Visa transactions per year, regardless of payment acceptance portal. So most people are not going to be in that realm. Most of them are going to be in that merchant level 4 realm. So any business or process less than 20,000 e-commerce Visa transactions per year, and all the businesses that process up to 1 million Visa transactions per year, regardless of the payment acceptance portal. So what this means is if you are between 20,000 and up to 1 million transactions per year, you're a level 4 merchant. Excuse me. And what that means is, or that gives you the ability to do what's called a self-certifying for PCI. Basically, you can download a form from the PCI website and you can go through it. Should be with a security practitioner to help you understand what you're certifying, and you can go through and validate that you have all the things in order for PCI. Now, I know what you're thinking. There is no PCI police. Nobody's going to come around and try to determine whether you're compliant. However, if you happen to be breached, PCI will come and get you if they find that cardholder data was lost. So when they come and get you, in addition to being breached, you could have fines and penalties of hundreds of thousands or hundreds of thousands or just all kinds of money, and up to and including being banned or prevented from processing credit cards any further, depending on how egregious the failure was on your part. So these penalties get very, very serious, and they can put a company out of business. GDPR, now this is specific to the EU, at least that's what people say. However, as you know, a lot of European citizens, they come to America, we vice versa, they do business here, they're going to websites of American businesses and so on and so forth. So when GDPR was passed, it said that any company that's handling the data, the personal data of a European citizen, guess what? They had to be compliant with GDPR. Now, the most visible and immediate changes that you saw came in the terms of service and other warnings that you saw pop up on websites. So about a year ago, I'm sure you remember every time you went to a website, there was a new banner, you must accept these terms and conditions. There was something new popping up that said you had to accept these new responsibilities or terms. And that was most likely related to GDPR. Why? Because it changed the way, it changed the level of responsibility for a business that handles the data of a European citizen. Now, these are the first part of the requirements, or what GDPR instituted. So you have to have transparent information communicated and modalities for the exercise of the rights of the data subject. So in other words, they need to know what you're collecting, it needs to be communicated to them, and they need to understand what their rights are as the data subject. When you see data subject, think of the end user. Information to be provided where personal data are collected from the data subject. They need to know where you're collecting the data. They need to know where you're not collecting the data. The right of access by the data subject means they need the ability to access the data that you're collecting, and they have a right to rectification in case there's any mistakes in the data. Right to erasure, a lot of people like this because this means this is a right to be forgotten. So any event that you're not dealing with a company or anything like that, the end user should be able to come to you as a law firm and say anything that you're holding about me regarding me that, obviously that does not break the law or break any compliance issues from a legal standpoint, they have a right to have that removed, erased, and gotten rid of. The right to be forgotten. Right to restriction of processing, notification obligation regarding recertification or erasure of personal data or restriction of processing. So this is talking about how the data is processed. Right to data portability. Now this is a very important one because basically they're saying users need to have an easy way to port their data from one platform to another or from one company to another. So that can have implications there. Right to object to you collecting data, automated individual decision-making, including profiling. And that was it for GDPR. And now as we move on to CCPA, the Consumer Privacy Act, this just went into effect this year, 2020. Now, businesses don't have to be located in California to be impacted. If a citizen of California is doing business with you, there could be impact. Citizens will be allowed private right of action under CCPA for security breach. So what does all that mean? That means that any citizen of California that's doing business with you, even if the law firm is in a different state, there could potentially be implications if something happens with their data. Okay, citizens are allowed a right of action, a private right of action. This means that if there is a security breach, the individual citizen, each individual citizen can bring a cause of action against you. This gets very expensive, and this is a really, really big thing. Oh, one thing I forgot to mention about GDPR, sorry. GDPR, the fine for GDPR, if you are found to have breached it, can be up to 3% of your gross income. So that there's substantial fines for violation of GDPR. Sorry about that. Back to CCPA. We covered this slide. So CCPA consumer benefits. They will also receive the right to request access to the actual pieces of data collected. All right, so it looks similar to GDPR, but this is a California specific law. The right to request opt-out, meaning directing a company to not sell their personal data to third parties. A right to deletion, the ability to request that a company delete personal information that's collected about the end user. So these things have to be in place if you're doing business with a California resident. Now HIPAA. So if you're if you're dealing with a lot of civil law, civil cases, you probably are familiar with HIPAA because you probably had to deal with client health records and things like that. And so HIPAA, basically, if you've been to a doctor's office, you know what the HIPAA form is. Basically ensuring that nobody that you don't want to have access to your data will get access to your data. So individually identifiable health information is protected health information. So if it can map down to the individual where you can be identified, that means it is supposed to be protected. Covered entities, those are responsible for following HIPAA regulations. Law firms fall in this category if you are holding your client's medical information. You are a covered entity. That means you must be HIPAA compliant. Now, HIPAA, a covered entity must make reasonable efforts to use, disclose, and request only the minimum amount of protected health information needed to accomplish the intended purpose of the use, disclosure, or request. In other words, keep it simple. Only to get the information you need, because the more information you collect on a client means the more responsibility that you have. Important fact, compliance is not security, but it is a good start. A lot of companies fight to be compliant. However, this doesn't mean that they're secure. There'll still be breach. You can be compliant with PCI, GDPR, HIPAA, and CCPA, and you can still get breached. Why? Again, because compliance is check marks. Remember, compliance is that date and time, right? So you were compliant on Monday, right? But because of some changes in either the regulation or the status of your company or the status of the environment, the information security environment, you are no longer compliant and you are no longer protected. Or even if you remain compliant, a new vulnerability has occurred that now makes you vulnerable to being attacked. So compliance is a good start, And I think, you guys should obviously be aware of these and try to work hard to be compliant so that you protect yourselves, your business, and your clients. Thank you, and I'll be back for part 3.